Draft Bail and Release from Custody Scotland Act 2023, Consequential Modifications Order 2024.
I call the Minister to move the motion.
Thank you, Mrs Harris. It's a pleasure to serve under your chairmanship, and I beg to move that the draft order, which was laid on 21st October 2024, be approved. And just before I begin my remarks, I want to welcome the new Shadow Scottish Secretary to his place, and also just to pass and to pass on the apologies to the Secretary of State for Scotland, who's in front of the Select Committee this morning. This order is the result of collaborative working between the two governments of Scotland and Westminster and supports the Scottish Government's decision to implement the Bail and Release from Custody Scotland Act 2023 in Scotland. The order before us today will be made under Section 104 of the Scotland Act 1998 in consequence of the Scottish Government's Bail and Release from Custody Scotland Act 2023. A Section 104 order is the most common type of Scotland Act order. They are used to make technical amendments to UK reserved legislation to facilitate the policy aims of an Act of the Scottish Parliament or secondary legislation made by Scottish ministers. Scotland Act orders are a demonstration of devolution in action, and I am pleased to say that this is the fourth Scotland Act order to be put to the House by this Government. I will now just go on to explain the effect of this order and the effect it will have and the provisions it will make. I should begin by explaining that extradition proceedings take place in summary courts, and these are magistrates' courts in England, Wales and Northern Ireland and sheriff courts in Scotland. This means that if there are changes to the legal framework for bail considerations in relation to those courts, it would also impact on extradition cases. That is what could happen in this instance, and so both Scotland's governments agree that it would not be appropriate, so we are using this order to prevent that. This order does not make changes to extradition law across the UK or affect current extradition policy and legal frameworks in any way. It ensures courts in Scotland continue to have the ability to consider the question of flight risk as a ground for refusal of bail in the context of extradition proceedings in line with the rest of the UK. The order will ensure that a limitation on the court's ability to remand persons at risk of failing to appear in court under the new test for bail in Scottish summary courts does not extend to extradition cases. This will mitigate the risks of a person wanted for extradition being granted bail under the new regime when they would not have been under the previous regime. Without this order being enforced, individuals accused of serious crimes who are wanted for extradition may be granted bail under the new regime because the courts would not retain their current levels of discretion to consider the question of flight risk. This creates risks in relation to the requested person absconding and evading justice. The Bail and Release from Custody Scotland Act 2023 was passed by the Scottish Parliament in June 2023. It seeks to ensure that, as much as possible, the use of remand for domestic criminal cases within the Scottish criminal justice system is a last resort, reserved for cases where public safety requires it or there is a significant risk of prejudice to the interests of justice. The Act limits the circumstances in which the court in summary proceedings in Scotland can refuse an individual's bail application by amending Sections 23B and 23C of the Criminal Procedure Scotland Act 1995. In particular, amendments to Section 23C include a new subsection which limits the extent to which a court may take into account any substantial risk of a person absconding or failing to appear when determining whether there is a good reason for refusing bail in summary proceedings. This would remove the ability of sheriffs to consider whether the individual in question may abscond from further proceedings unless they have already failed to appear in a Scottish domestic criminal court case. It should be noted that these restrictions would not apply to judges who are considering whether to refuse bail in solemn proceedings, which are the equivalent of Crown Courts in England, Wales and Northern Ireland. The Extradition Act 2003, which applies across the whole of the UK, prescribes the cases of individuals arrested subject to an extradition request from an international partner are to be overseen by a specialised extradition judge. In Scotland, this is the Sheriff of Lothian and Borders. When hearing extradition cases, the Sheriff has the powers available in relation to bail, as if the case were summary proceedings in respect of an offence alleged to have been committed by the person. Cases proceeding by way of summary proceedings in Scotland involve less serious crimes than extradition cases typically do. Under current Scottish bail legislation, the Sheriff considering bail in an extradition case can consider the question of flight risk from the very outset of a case. This is important as the nature of extradition means that the individual in question may pose a substantial risk of absconding or failing to appear. This order ensures that sheriffs retain their current levels of discretion to decide whether those subject to an extradition request are remanded in custody while they wait for hearing, and I beg to move.
The question is that the committee has considered the draft Bail and Release from Custody Scotland Act 2023, Consequential Modifications Order 2024. I call the Shadow Secretary of State.
Thank you very much, Ms Harrison. It's a pleasure to serve under your chairship this morning, and I'd like to thank the Minister for his kind remarks and welcoming me to this post. I'm very glad to make it in time for this delegated legislation committee. Today I intend to keep my remarks brief. You'll all be pleased to learn we will not oppose the bail and release from custody Act Consequential Modifications Order, although the issue it seeks to rectify is one that perhaps should not have arisen in the first place. We do nonetheless want to ensure UK-wide consistency because this is clearly an important area of the law with real-world consequences. We would want the parameters in Scotland for granting or rejecting bail and extradition cases to be in line with UK-wide standards. And it cannot be right that under the Bail and Release from Custody Scotland Act passed by the Scottish Parliament last year, sheriffs hearing extradition cases in Scotland would no longer be able to remand an individual accused of an offence on the basis that there is a high risk that that person will abscond, unless the said individual had previously failed to appear in court for that offence, or if one of the charges in the live case is one of failure to appear before a court. So it goes without saying that flight risk should be a serious consideration, and a situation where courts in Scotland are more limited in this respect than in other parts of the UK would not be right. This is not least because people accused of extradition proceedings are often considered at risk of flight. Maintaining the integrity of the Extradition Act 2003 and of the UK's broader extradition system is therefore a priority, both for our own sake and also for that of countries with whom we have extradition arrangements. I note that the UK Government has not held a formal consultation on this order, but has put on record that it has consulted with the Scottish Government. So could the Minister shed any further light on those discussions and how we might avoid similar circumstances arising in the future? But to conclude, Madam Chair, we do not intend to stand in the way of this order today.
Minister McCluskey.
Thank you, Mrs Harris. I would like to thank members for their contributions today and also welcome the Shadow Secretary of State's support for the order, and obviously agree with him about the need to maintain the integrity of the UK extradition system. In terms of his question regarding how we avoid any such policy before, this has actually been quite a collaborative process between the Scottish and the UK Government, which was started obviously under the previous government in which he served. And I think it's important that the consultation that happened at the time was robust. It would not be something that would ordinarily be relevant for a public consultation, but I wouldn't necessarily agree with the Shadow Minister that there's a problem here. There was a robust discussion before, and this was flagged in terms of the issue and discussed, and we came to the conclusion that this order was the way to pursue this. And there is an ongoing, as part of resetting the relationship, as the Scottish Government and the UK Government are doing, there are ongoing discussions on a whole range of issues where we are ensuring that we have a close working relationship with the Scottish Government in future. So yes, welcome his support and his support for this order today. So in closing, this instrument demonstrates the continued commitment the UK Government has to work with the Scottish Government to deliver for Scotland, and on that basis I beg to move.
The question is that the committee has considered the draft Bail and Release from Custody Scotland Act 2023, Consequential Modifications Order 2024. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order, order.